Good afternoon, everyone, and thank you for joining us for our Life, Justice, and Peace webinar series and Richard Doerflinger's presentation on assisted suicide, the ethics, the law, and the dangers. I'm Tracy Yackley, Operations Manager for the Washington State Catholic Conference, and with me today is my colleague, David Valmonte, Social Media and Website Specialist. Richard's reputation certainly precedes him, and we are so grateful that he is here with us today. Richard M. Doerflinger retired in 2016 from the U.S. Conference of Catholic Bishops, where he had served as Associate Director of the Secretariat of Pro-Life Activities. For 36 years, he prepared testimony and other materials on abortion, euthanasia, and assisted suicide, and other life issues. His writings have appeared in journals on ethics and law and in many Catholic magazines and newspapers. He is a fellow at the University of Notre Dame's De Nicolas Center for Ethics and Culture as Associate Scholar for the Charlotte Lozier Institute and an adjunct fellow in bioethics and public policy at the National Catholic Bioethics Center. He holds BA and MA degrees from the University of Chicago and conducted doctoral studies in theology there and at the Catholic University of America. Welcome, Richard.
Thank you. Thank you. Well, yes, as you said, I spent 36 years at the Bishops' Conference, and 30 of those years was among other things, working on the issue of assisted suicide. Beginning when I attended the first annual convention of the Hemlock Society in 1986. So I've been at this quite a while. And then when my wife and I moved to Washington State after my retirement, I got to work on public policy there and worked with a group of wonderful people fighting against the efforts to further expand Washington State's law legalizing assisted suicide, which would have dropped what few and paltry safeguards remain in the law. Unfortunately, after 3 years of debate, that expansion passed, and now we have a worse law than ever in Washington and in some other states as well. Let me begin with the ethics of this, because it's often misunderstood, the moral equation in this. Pope St. John Paul II, in his great encyclical on the Gospel of Life, said, "Suicide is always as morally objectionable as murder. The Church's tradition has always rejected it as a gravely evil choice. To concur with the intention of another person to commit suicide, and to help in carrying it out through so-called assisted suicide, means to cooperate in and at times to be the actual perpetrator of an injustice which can never be excused, even if it is requested." I think that first sentence is kind of shocking to some people. Always suicide as objectionable as murder, but you're not hurting anyone else. And yet, you, as a child of God, as someone made in the image and likeness of God, has a human dignity that is the equal of everyone else's on earth. And so to destroy that gift of life is also throwing a gift back at the Creator and destroying someone of infinite worth, that is yourself. And I think it's important also to say assisting someone else in committing suicide is that means that that person is really as responsible for the death, maybe more responsible for the death than the person who has requested it, him or herself. St. Augustine had something very interesting about this to say in his great work, The City of God. He said, "The law prohibits suicide where it says thou shalt not kill, because the love of our neighbor is regulated by the love of ourselves. As is written, you love your neighbor as yourself." So in other words, if you can't kill anyone else because you love their lives, you are equally obligated to love your life and to protect it and respect it. And so he made a very tight connection between killing yourself, killing others. Three important clarifications. What this does not say. First of all, personal responsibility for this. The act is objectively evil. the personal responsibility for it may vary quite a lot. And as the Catechism says, grave psychological disturbances, anguish, grave fear of hardship, suffering, or torture can diminish the responsibility of the one committing suicide. We should not despair of the eternal salvation of persons who have taken their own lives. And from the field of secular psychology, this from Dr. Herbert Hendon, internationally seen as a great expert on the psychology of suicide. Nearly 95% of those who kill themselves have a diagnosable psychiatric illness in the months before that. So, and that's equally true of people who ask for an early death during a serious or terminal illness. They're usually suffering from a treatable depression. And so the moral responsibility, you can't assign full moral responsibility to someone who is suffering under mental disturbance. The moral responsibility may be primarily that of the person who assists the suicide. Second, responding to the argument from autonomy, uh, sometimes expressed as, well, whose life is it anyway? That's a sign of a modern model of the human person that is deeply at odds with the biblical and the Christian idea of the human person. That model is called expressive individualism. I am an autonomous will. My goal in life is to express my desires, my will, and to advocate those to others. And everything other than my will, even my own body, is just an instrument, a means to fulfilling that will, which really even reverses the priority of our own Declaration of Independence. The inalienable rights first life, then liberty, and then the pursuit of happiness. One book I'd like to recommend for its treatment of how that model of the human person distorts and overrides moral responsibility in these areas is by O. Carter Snead, who's a law professor at Notre Dame, What It Means to Be Human. Anyway, the response to whose life is it anyway is first, it's God's. For Christians, for people of any religious frame of mind, it's God's gift of life. We don't have absolute dominion over it. We're called for careful stewardship over it under God's loving eyes. But even from a secular point of view, my body is not just another possession, like a tool. It's a very integral part of me. It's the physical reality of who I am as a human person. And to destroy that life destroys all possible autonomy in this world. It destroys autonomy. It's like it's like the self-contradiction involved in saying I'm going to freely sell myself into slavery and therefore deny all future freedom, because liberty depends on actually having life. The third thing I want to say is this does not demand that we do everything possible to prolong life during serious illness. Religious point of view, Christian point of view, is that there are natural limits to our earthly lives. And death can even be a gateway to eternal life if we're facing death and accepting it when it is inevitable. But again, even from a secular medical point of view, there are important distinctions here between uh, what is done in refusing excessive treatment versus taking your own life. One is a direct act aimed only at taking that life, and the other is omitting medical interventions that are holding death off, sometimes with great burdens and hardships of the patient uh, that are exaggerated compared to what they can achieve, otherwise known in the Catholic tradition and in modern medicine as well as extraordinary means. And it's different in what's usually intended. If I'm saying I cannot endure that final round of chemotherapy, that radiation treatment, is doing me as much harm as good. I'm not intending to die. I'm intending to free myself of this disproportionately burdensome treatment, even if I know death may occur somewhat sooner. That is not suicide. And the Supreme Court, in its case Vacco versus Quill, this was rejecting the idea of a fundamental constitutional right to assisted suicide. It draw a very clear distinction in the law between those two things. It is not a violation of equal protection to allow refusal of extraordinary means for everyone and to say that assisted suicide is wrong for everyone. So I next want to talk about these laws. What do they do? There are laws legalizing assisted suicide. I used to always say physician-assisted suicide, but now increasingly states are changing the law to allow a broader range of people to assist: nurse practitioners, physician's assistants, and just standard nurses in some cases. But these medically assisted suicide laws are in 11 jurisdictions, 10 states and the District of Columbia, beginning with Oregon in 1994 after a legal challenge and some votes on a new initiative that was designed to rescind it after it was passed. It took effect in 1997. And then the next was Washington. Uh, and as you can see from the slide, a number of others have joined since, most recently Delaware this past year. But I should note that 10 states debated bills to legalize assisted suicide just this past year, and 9 out of 10 rejected it. So this is not a kind of juggernaut that is inevitable and overwhelming. It is something that in most cases fails. In fact, more states since Oregon have passed new laws against assisted suicide than in favor. And uh, so I have a slide here listing those states. 12 states in either passing completely new laws against it or improving and tightening their pre-1997 laws. So this is very much, it continues to be a live debate and a debate that can be won or lost depending upon, uh, sometimes depending a lot on how much money the two sides have, but always depending on the alliances, the coalitions we are able to form among medical, disability rights, religious, and pro-life advocates, and the cogency of the arguments we are able to bring to bear. Uh, there were there were already laws in 25 states before 1997 that remain in place now as well. So the laws have always been promoted by saying, look, this is going to be a very limited last resort. This is something that is hedged about with all kinds of safeguards against coercion or abuse. And just quoting the voter's guide that was put on presented with the ballot initiative in 2008. So this is from Washington State. There are multiple safeguards in Washington's death with dignity law. These safeguards include independently witnessed oral and written requests, 2 waiting periods, mental competency and prognosis confirmed by 2 physicians, and self-administration of the medication. Only the patient and no one else may administer the medication. So I'm going to ask, do these laws really advance compassion and choices, which is actually the title of the major national group promoting these laws in recent years? And do the safeguards work? Well, first of all, in laws like Oregon's and Washington's, and those are the model for most of the other states that have passed these laws, who is really making the choice? The Washington Voters Guide in 2008 said the decision belongs with the patient and their family and no one else. Actually, the laws routinely do not even require that the family is notified. So it's not at all necessarily patient and family. But there are also a long list of people with their own agendas who control the process more than the patient does. The written request has to have two witnesses. One can be an heir to the estate of the person who's seeking death. The other can be an employee of the long-term care facility where that person is, who may have their own financial and practical reasons for wanting this bed to be free. The prescribing physician determines whether the patient is competent, what the illness is, whether it's going to be likely to cause death in less than 6 months, controls the information the patient receives. And doctors have told me, if I'm the one who's telling the patient what his illness is and how bad it's going to be and how difficult the treatment is going to be, I can really guide that patient's choice as to whether they're going to get treated or ask for that lethal dose. Is the patient who prescribes the lethal dose signs the death certificate. And it's required in Oregon and Washington to list the underlying illness as the cause of death, which prevents an autopsy. It prevents any outside scrutiny by anybody but the physician who was willing to be involved in this. The state health department has to accept what the physician says happened. The very first year that Oregon reported its year of cases, the health department issued a brief summary of what that showed. And they admitted rather candidly that for all the state health department knows, the doctor's account could be a complete, quote, cock and bull story, but they have to accept it. They have no authority to do any further scrutiny than just to accept that physician's word. It is a closed system, not for uncovering the facts, but for concealing them. Then the consulting physician is chosen by the prescribing physician, presumably because he knows that this is his friend who's going to say, me too. There have never been any reports that the second opinion ever differs from the first opinion. No reporting by other physicians, even those who the patient consulted first, who had concluded that the patient did not qualify for lethal drugs. Once they say no, the patient or the patient's handlers simply go to the next physician who's more likely to say yes. So we never even hear about those unless people go to the press themselves and say, but I said this patient does not qualify. Then there are other public and private entities involved, not necessarily mentioned in the law, but they have a great influence. In Washington, the assisted suicide group End of Life Washington has testified to the legislature that it has been involved in 95% of the cases. So they direct patients to the physicians that are totally in sync with the agenda of End of Life Washington, pro-assisted suicide physicians. They can help provide the witnesses. They can even assist at the bedside. There is no requirement for the physician to be present when the patient takes the drugs and dies, and almost never is the physician present there to see what happens and who is really administering that dose. There are the private insurance companies. Dr. Brian Callister of, uh, I think, Nevada, but he once had patients consult him as an expert in cancer to ask for further treatment. And he recommended to them a treatment that he thought could help to stave off the cancer and extend their lives. And he called their health insurance companies, one in California and one in Oregon, and and said, I think you should cover this. And they said, no, we're not going to cover that. That's expensive. But have you talked to the patient about assisted suicide? So here's the thumb being put on the scale by insurance companies saying, we'll pay for that. Very cheap, very cost effective, always works, but not for treatment that could cost some money, but may help to alleviate the disease. And then in Oregon, you have the state government as a major insurer, the Oregon Health Plan, which is a rationed health plan. Depending on the state budget in any given year, they have a long list of different treatments, hundreds of treatments, and then depending on the budget, they cut off at a certain number what they're willing to reimburse for and what they are not willing to. Assisted suicide ranks very high on the list. That's always funded. It's listed under palliative care. In two cases, Barbara Wagner and Randy Stroop, the patients have come forward and complained that they received a letter in the mail from the state health department saying your request for reimbursement for this possibly helpful treatment is denied, uh, but have you considered assisted suicide? In Oregon, last year, 77% of the patients getting the lethal drugs either had no insurance or had only governmental coverage from this Oregon health plan or from Medicare. In Washington, in 2018, 76 patients were in that situation. No insurance or only governmental insurance. After 2018, the state stopped reporting that figure, maybe because people like me are making a big stink about it. So is a voluntary choice by a patient of sound mind? Is the patient even making a real and responsible decision? The safeguards, as the Washington law was originally passed, said there are two oral requests 15 days apart. At the time of the second request, the patient can then make a written request, written and witnessed. But a mental health evaluation is only done if one of those two physicians thinks the patient has a depression or other mental disturbance that impairs judgment. As Dr. Hendon and with palliative care expert Kathleen Foley have written in an article in the Michigan Law Review, the doctors who are into this, they assume that because the patient is requesting a lethal dose, they're showing sound judgment because they're so much in favor of it themselves. Almost never is a patient ever referred for a psychological evaluation. Fewer than 1% in Oregon last year, and in 5 of the last 7 years that are reported, Washington did not report that any, and there were hundreds each year, that any patient was referred for psychological evaluation. In both states, cases have come to light in which the patient receiving the drugs, so their request was accepted, they were suicidally depressed on a regular basis when they were not physically ill at all. In the case of one of them, Michael Freeland in Oregon, he was known so much to have bouts of suicidal depression that the legal authorities sent police to his house to confiscate all of his guns. They found the vial with the lethal drugs in them in his medicine cabinet and left that there because that is not assisted. That's not suicide. That's death with dignity. Robert Fuller in Washington, same thing. He had started thinking about suicide when he was 8 years old, when he found the body of his beloved grandmother floating in the river. Uh, these are people whose main ailment was simply suicidal depression. And but when they had a serious physical illness, uh, that didn't change the fact that they were operating under depression. It just changed other people's reactions to them. Uh, the prescribing physician does not assess the patient's competency or whether they're making a voluntary decision at all when the drugs are taken. And as I've mentioned, they're seldom even there. A vast majority of the times, they're not even there. And the funny thing is, the uh, the assisted suicide groups always say, by obtaining these drugs, that doesn't mean the patient is necessarily going to be taking them. Some people just want that on hand in case things get really awful, and they want that in the bedside table or in the medicine cabinet, whatever, just in case. It gives them a peace of mind that they have an out if things get awful. Well, doesn't that mean that it's when the drugs are actually taken that you really need to be checking for competency and voluntariness? And nobody does that. Only the patient can administer. This has been, very seriously insisted upon by the groups promoting this. Well, in Oregon, very early in the process, very early in the law's effectiveness, the state attorney general's office was told that a patient who was too physically weak to put the pills in his own mouth had them put in his mouth by his brother, which violates the law, the letter of the law. And he said, well, we may have to allow that because if we don't allow people with physical disabilities to have it administered by someone else, we may be violating the Americans with Disabilities Act. So actually, we can make a very good case that allowing this for people with serious illness, which generally involves a disability, and not allowing it for other people in general violates the Americans with Disabilities Act. But that's something I'll get back to. In Washington, the law has a very odd definition of self-administer. Self-administer is defined as the patient must be the person who, quote, ingests the drug. Well, that means he's the one who swallows or absorbs the drug. It is not inconsistent with somebody else putting them into his body. And so already we have this slippery slope in a creative definition of the legal term, from assisted suicide to outright homicide. In 2024, last year, a bill was introduced in California to make that explicit and say others can perform the act. It did not pass, not yet. But in fact, the initial legal proposals that groups like the Hemlock Society had proposed in the 1980s and in the early 1990s were to legalize active killing by physicians, to legalize euthanasia as well as assisted suicide. The Oregon proposal that passed in 1994 was announced as a tactical decision to get a law into place that was more likely to pass, could be expanded later, and that is what is now happening. Is this about compassion for pain and suffering? Well, the funny thing is, a minority of patients in both Oregon and Washington are citing pain or even a fear of possible future pain as a reason for their request for the drugs. 34% in Oregon and 41% in Washington. Here's what is really driving this agenda for the patient. They say they're less able to engage in activities making life enjoyable. They're losing their autonomy. They're losing their dignity. They're becoming a burden on others. That one is particularly distressing. Uh, we in Washington, when they were deciding whether to expand Washington's older law, and they finally did so in 2023, the legislature commissioned a study of how the patients and their caregivers felt the uh, about the current safeguards, which the survey described as barriers to access, and which of those barriers they thought should be loosened up so that people can access this solution more readily. Uh, Becoming a burden on others. It turned out that among the patients that were still alive but had already requested the drugs, the caregivers were more likely to want these safeguards eliminated, these burdens eliminated, were 2 to 3 times more likely to say that than the patient was. And so we can figure out who thought the patient was a burden first of all. But patients very easily, if they are the dependent and helpless people in the relationship, they can internalize those negative attitudes toward them from those in the same household and then become uh, likely to say, yes, I am a burden on others. And that is why, because they can hear that in other people's voices and other people's behavior. So that's particularly alarming. Is the end by assisted suicide painless and peaceful by itself? Well, at least 84 patients in Oregon have had complications. I mean, that doesn't seem like a lot when there were thousands of these cases over the years from 1997 to the present. But and 9 even regained consciousness. They did not die from the pills of the dose. But that figure is unknown for another 2,037 patients because only the doctor can report those things, and the doctor is almost never there. So we don't know. It could be hundreds, it could be thousands of cases in which complications have occurred, and the death was actually a rather uh, painful or alarming sort of experience. Patients have taken as long as almost 6 days to die. Uh, 35 complications at least, as far as we know in Washington. But again, after 2018, the state stopped reporting that, how many there were. And they had taken as long as 30 hours to die in the years leading up to 2018. After that, we don't know. But is it at least compassion for a terminal illness? The patient is going to die in 6 months anyway. Well, in both states, most patients have had cancer, but increasingly, the conditions making them eligible for assisted suicide in Oregon have included circulatory or respiratory illness, neurological conditions, arthritis, diabetes, anorexia, which is a psychiatric illness. It's when you are driven by your mental disturbance to stop eating. Uh, Benign or uncertain tumors. In other words, even if the tumor was benign, was not malignant, they were getting the lethal pills. And even, quote, what the health department says were medical care complications. So it's, in other words, it's injury that was caused by the medical treatment up to that point. People say that nice thing about being a doctor is you can bury your mistakes. This is a very obvious example of that. And there are always some that are other or unknown because the doctor never even bothered to cite an illness. In Washington, the conditions are expanding as well. Uh, Cardiac, respiratory, neurological, and other. In 2022, for example, there were 15 cases of unspecified other and 13 cases of unknown or missing. Just no illness cited on the doctor's form. Now, in 2018, the Oregon Health Division was asked by someone doing an investigation of how this legal system works. When do you see a condition as terminal? Is it when it's going to bleed to death in 6 months, regardless of treatment? Or is it enough to, is it called terminal if it was only going to cause death in 6 months without treatment? And they said, oh, it's the latter. So that's why you can have anorexia as a terminal illness. If the person stops eating and they refuse force feeding from others, well, they're terminal. I mean, without food, you're going to die in weeks or days. So that's why you can have diabetes as a terminal illness. If you stop taking insulin, you're terminal. So this is expanding to cover a great many serious but not terminal illnesses. If you are feeling like you want to be rid of your chronic illness or disability, all you have to do is refuse treatment or have it denied by a doctor or insurance company, and then you're terminal enough for the lethal dose. So in 2024, last year, 376 patients died from the lethal drugs. 43 had received the drugs in previous years. So clearly they didn't die in less than 6 months. Overall, the time from the first request for the lethal drugs to the patient's death from taking the drugs has been as high as over 5 years, over 10 times that 6 month prediction. Again, in Washington, they keep ceasing to report the most interesting things that are happening in the state. But in 2018, patients had lived as long as over 2 years after receiving the drugs. 12% of those who died that year had outlived the 6 month prognosis. After that, we don't know what the maximum time is because over the last 6 years, the state has not reported. That's not counting survival time for the patients who did not take the drugs. So that may well be longer. I mean, if you take the drugs within the next year or two, it's never going to be proven how long you would have lived without taking them. Over the 15-year process in Washington, there are 82 patients who received the drugs, but for whom the state health department has never seen a death certificate from that time to this. So where's the accountability here? How do these safeguards work? Well, if the doctor does not file his required report about the patient's terminal illness, competency, voluntariness, and so on, within 30 days after prescribing the drugs, they fall outside the Act's protection. They can be prosecuted under other laws, including Washington's law and Oregon's law, that remains on the books, treating assisting a suicide as a felony. They can be prosecuted by laws that punishable up to 5 years in prison. In Washington, there's even a crime called a controlled substances. A patient takes a lethal overdose of drugs, and the doctor or the person, whether doctor or not, who provided the drugs is guilty of a homicide. And that has a longer prison term. They should also be subject to civil liability, like lawsuits from the families. And they could lose their license if it's referred to the state medical board. Without those doctors' reports, there is no evidence, not even hearsay from the physician, that the patient had an illness, much less a terminal illness, made a voluntary request, was competent, and so on. The Washington Health Division, its annual reports always say to comply with the Act, attending physicians and pharmacists must file documentation with the department. But, and I'll show you this more in more detail in a second, that requirement is often ignored. In Oregon, over the 27 years the law has been operating, 2 physicians have been disciplined by the state medical board after they were referred by the state health department for action. In Washington, none has been reported. Neither state has ever referred a physician for possible prosecution. Now, I know this chart is rather daunting, but let me boil it down for you. I was recording this from year to year. In each state, the health department's annual report always has an appendix saying, it always reports how many patients got these drugs. And it always reports how many of the physicians' forms were filed with the state. Over the years since 2009, in Washington state, 262 cases in 262 cases, the department has never seen a physician's form, even claiming that the physician made a voluntary request or was sick. In 307 cases, the doctor has never submitted that written request from the patient saying this is what the patient wants. And in 302 cases, there's no report from a consulting physician that was supposed to be providing that second opinion. So you have hundreds of cases in which, under cover of the so-called death with dignity law, physicians, by the letter of the law, have been committing felonies. Nobody's doing anything about it. And I presented these facts to the state legislature when it was considering expanding the law further. I could almost hear their yawns as they ignored anything about that. So over 3,700 lethal prescriptions in Washington, over 300 cases in which the key safeguards providing the legal protection were ignored. Well over half of those violations, by the way, occurred in the last 5 reported years. So this is stepping up. This is increasing. As some doctors say, oh, yeah, I never filed any of that. I never made any claim at all. I just gave them the drugs. Other physicians are learning that it's safe out there to do this. And yet the department's reports in Washington listed those cases among the number of cases for that year that were valid, quote, under the terms of the law. So contradicting even the state's own description of what the terms of the law are. What's the collateral damage here? This has effects on people who never requested the lethal drugs as well. Because it is true that every year some dozens of patients receive the drugs but have not taken them, have not ingested them, to use the Washington's term. Unused lethal overdoses, for all we know, could be going into the general population, used by others. Seattle in recent years has talked about an epidemic of opioid overdoses leading to people's deaths. In Oregon and Washington, over 2,500 lethal drug overdoses, presumably with labels on the bottle saying how to use them to take a life, remain unaccounted for. In Washington and in Oregon, there have been increasing overall suicide rates, sort of garden variety suicides that do count as suicide in the law. And we can see that these laws have had a chilling effect on legitimate treatment for terminal illness and on palliative care to ease people's physical, mental, and spiritual suffering. Uh, if you're going to tell a doctor that he always has available a quick and easy solution to any difficult terminal illness, that means he doesn't have to learn all the details of how to do the difficult job of actually caring for that patient's illness. Some of them are going to take you up on that. And Oregon, for example, has been found to have a lower grade from national healthcare organizations in terms of uh, dealing with end-of-life care since it legalized assisted suicide. I have a reference here to an article in which I documented those trends. So where is this heading? Well, now we have, in the states that have already legalized this, we have the expansion agenda. The In Oregon and in other states, the waiting periods are being cut back or eliminated. Uh, Residency requirements that this has to be just patients who actually live in the state are being eliminated. That's happened in Oregon and Vermont and has been California as well, I believe. In Washington, you have non-physicians involved in diagnosing, evaluating mental health. All you need is a social worker to say whether you have clinical depression in Washington. Delivering drugs by mail, parcel post, or messenger, in which case you don't really know who actually even received the drugs. It need not be the patient. And the state of Washington has begun to give some scrutiny to health facilities like Catholic health facilities that do not participate. I think the next step there is to begin to put pressure on them, asking them why you're not giving this basic uh, health care, and so on. Uh, Expansions that are not or not yet formalized by statute. Uh, a lawsuit in California tried to get the courts to allow active euthanasia, homicide for patients who cannot self-administer because of a physical weakness or disability. Uh, the bill introduced in last year in California to include non-terminal illnesses explicitly, lethal drugs for patients with dementia, and administration by IV. I mentioned the Oregon Health Department's interesting definition of terminal illness. In Colorado, two patients already received the lethal drugs whose only illness was anorexia. Actively encouraging seniors to end their lives as a matter of cost saving is something that's been explicitly endorsed by Derek Humphrey, the founder of the Hemlock Society that got this agenda going in the first place. He has said this explicitly in his book called Freedom to Die. Uh, it's not about freedom if the young able-bodied people are putting pressure on you to do it because you cost too much. And so these groups are trying to get a suicide haven in every region of the country so that each region can have a suicide haven, a state to go to get this. Well, what is the issue really about? I don't think it's about the patient's choice, and it's not about compassion for patients in pain, which is sort of a secondary consideration and not a very frequent reason why people even seek this. As disability groups like Not Dead Yet and the Disability Rights Education and Defense Fund have very cogently argued, this is about a discriminatory judgment by us, the not so sick, the able-bodied, about the value of some other people's lives, otherwise known as ableism in the disability rights community. The able-bodied, generally able-bodied voters and legislators are choosing to authorize suicide prevention for those people who are more like them, who have lives worth living in their view, and suicide assistance for those who have lives that are less worth living. They do that before any particular patient is requesting the drugs. That's the choice that the legislature or the voters impose upon patients to put a thumb on the scale when the patient has to decide, what am I going to do? So for those patients, in the eyes of the state, there's no countervailing value that outweighs the choice for death. And even that choice will be influenced by the prejudicial view the rest of us have enacted in our law. It is an issue of civil rights, but not in the way that supporters of this agenda assume. Uh, Now, I believe my generous hosts at the Washington State Catholic Conference are going to email to everyone a two-page outline and with links to documentation, articles, and links to these state reports I've been citing, if you want to go into these things more thoroughly. There is a lot of information on this, and a lot of it is not generally known to legislators because all they're hearing is uh, the slogans about choice and compassion, and they're not looking into this deeply. That's our job, and we need to be educating them on the matter. This is I'm 72 now myself, and so I'm more active on this issue than ever because I'm becoming convinced that the life I save may be my own. So as you get older, I hope you'll think about getting more involved as well. Thank you very much, and I'm very interested in questions.
Thank you so much, Richard. And we do have a couple of questions. What are the next steps you, as advocates, that we can take in Washington State to make a difference in this area?
I think, I mean, the first thing is to understand the law, what it has now done, this expansion agenda, and and to publicize the fact that the same groups that promise these essential safeguards that would prevent abuse are now going back and contradicting themselves and saying we don't need safeguards against abuse. We're just going to do this and treat it as basic health care, even though the evidence is that the safeguards are being readily violated, and these expansions are going to make sure they're violated far more often than before. The other thing, and this is absolutely essential, is to make common cause with physicians and nurses who are concerned about this. Uh, one thing we did when they started saying we're going to expand the medical practitioners who can provide these drugs to nurse practitioners and physician's assistants. Well, we got some nurse practitioners and physician's assistants to say, this is not a responsibility that I want, and it's not one that anybody should have, speaking for themselves. Uh, and to make common cause with the disability rights movement. Many of the groups in that movement are quite secular, and they will not disagree with us on other moral issues like abortion. But on this issue, they are the most persuasive and uh, and dedicated people saying this is not freedom, this is discrimination. This is the state and the medical profession saying our lives are not worth fighting for the way other people's lives are. Um, and of course, it also means keeping track of these trends. I think the vast majority of people, the audiences I talk to and so on, they don't even realize, they don't know that since Oregon passed its law, more states have passed laws against this than have passed laws in favor of it. The advocacy groups, they paint this picture of, this juggernaut that is spreading throughout the country. Last year, West Virginia, which already had a law against it, they actually passed a constitutional amendment saying, as a matter of constitutional law, you can never have a law in West Virginia that allows for assisted suicide for anyone. So this is something that should give us encouragement that it is not all over. In this past year of 2025, 10 states dealt with bills to legalize this. 9 of them rejected it. One, Delaware, unfortunately, did pass it. It passed by a margin of one vote in House and in the Senate, and then the governor signed it. Uh, so these decisions this is a winnable issue. It is something that we need to be giving people more education on and more information and alerting them to the dangers and the broader agenda that is going to be endangering a far greater sweep of our population.
Thank you, Richard. What might be our last question for today, and if we have not been able to get to your question, please don't hesitate to email us at wcatholics.org. You can email advocacy@wcatholics.org, and we'll make sure that that question gets answered. Richard, what protections exist in law for patients who do not want assisted suicide but are denied treatment by their insurance companies?
I'm sorry, what about the patients who,
Uh,
could you repeat that?
Patients who do not want assisted suicide but are denied treatment by their insurance company, how does the law protect them?
Uh, the law does not necessarily protect them because most of these decisions are by private organizations that make their own decisions about where the cutoff is in terms of what they see as cost-effective treatment. Uh, Now, if you're dealing with um, Medicare, for example, and most of the people um, who are getting these lethal drugs are over 65, as I am, and so likely to be on Medicare. You have protections there, not in favor of getting everything that you may try to request as treatment, but certainly against getting assisted suicide from Medicare. Every federal health program is barred by law from being involved in any way with assisted suicide. Uh, that's due to a law that the Bishops' Conference and others helped pass back in 1997, the Assisted Suicide Funding Restriction Act. But you know, you have you have the option of seeking, if it's private insurance, you have the option of seeking other insurance. And in many cases, you can get your medical professional, your physician, to go to bat for you with these companies and help to persuade them that this is a reasonable treatment and it can have real results. Uh, it's something that you need a medical professional on your side, and it's still no assurance that the insurance company is going to say yes to your physician
Mhm.
either. So my broadest recommendation is shop carefully and see see what other people who may have some of the same health concerns have had a positive experience from their insurance company with.
Thank you so much. And this is all the time we have for today. Thank you, Richard, for joining us and for sharing your expertise with us on this end of life issue as we as Catholics work diligently to protect the sanctity of life. We will email the resources you provided to all registrants when we send the link to your presentation. Many thanks to all of you for attending. We hope that you will subscribe to our Catholic Advocacy Network at wacatholics.org. This way, you can stay up to date and join the WSCC in advocating for or against various bills that will impact life and justice in Washington State when the 2026 legislative session begins in Olympia on January 12th. Thank you all again and have a wonderful day.